In this video, we're unpacking Section 13 Title and Vesting, a critical part of the residential purchase agreement that explains how ownership of the property is transferred and insured. In this section, we'll walk through 1. How the preliminary title report is provided and what it means. 2. What encumbrances and restrictions the buyer takes the property subject to. 3. What the seller must clear before closing. 4. Seller's duty to disclose known title issues. 5. Federal reporting requirements for certain buyers, GTO rules. 6. How the buyer chooses vesting, their legal form of ownership. 7. Which title insurance policy the buyer receives at close of escrow. By the end of this lesson, you'll understand exactly how title is reviewed, how it's insured, and what agents must communicate to protect their clients and keep the transaction compliant. Let's get started with Section 13 Title and Vesting. Section 13A, Preliminary Title Report. What the contract says in plain English. Within the time specified in Section 3N, 1. The person responsible for title fees, defined in Section 3Q, 8, must make sure the buyer receives a current preliminary title report. If buyer is paying, the buyer must act diligently and in good faith to get that report on time. A preliminary report, prelim, is not the policy. It's an offer from the title company showing how they are willing to insure title and what exceptions/issues exist. The title company must search the general index, judgment/abstract index, for all sellers except banks or institutional lenders selling REO property, corporations, government entities. Remember, the prelim is the X-ray of the property's title. Your job is to read it and see what's there. Liens, easements, CC and RS, HOA matters, etc. always match the legal description, APN, and vesting on the prelim to the contract and MLS. Section 13V, Condition of title / what buyer takes subject to. Core idea, the buyer takes title in its present condition subject to all encumbrances, easements, covenants, conditions, restrictions, rights, and other matters, recorded or unrecorded, as of acceptance, except. For anything that is not being transferred to buyer, seller must take the necessary steps so buyer receives title free and clear of that lien/matter. By default, buyer is accepting existing non-monetary items, like easements, CC and RS, and recorded restrictions. What must be removed? Seller's loans, liens, and any other item seller has agreed in writing to clear before closing. If buyer doesn't like a non-monetary item, for example a recorded view easement or shared driveway, they must resolve it during the contingency period, not after closing. Section 13C, Seller's duty to help clear title. If escrow or title needs information to clear title, seller has 7 days after request to provide it to escrow. For examples, payoff info, statements, trust documents, death certificates, copies of recorded agreements, etc. Section 13D, Seller's duty to disclose title matters. Within the time specified in Section 3N, 1. Seller must disclose to buyer all matters affecting title that seller knows about, whether of record or not. Examples, unrecorded agreements, shared driveway deals, parking agreements, boundary understandings with a neighbor, known disputes or claims about boundaries or easements. Any known issues not yet of record, e.g., pending liens, notices received. This section reminds seller, if you know something about title, even if it's not recorded, you must disclose it. Section 13E, Geographic Targeting Orders, GTO, / anti-money laundering if buyer is a legal entity, LLC, corporation, etc., purchase price is at least $300,000 and purchase is made without a bank loan or similar external financing, then a Geographic Targeting Order, GTO, from FinCEN may require the title company to collect and report certain information about the buyer, depending on the county. Buyer agrees to cooperate with the title company's efforts to comply. This is the anti-money laundering paragraph. If your buyer is an LLC paying cash, expect title to ask for extra information and ID. This is federal compliance, not optional. Section 13F, Deed, Conveyance, and Vesting Instructions. After close of escrow, buyer receives a recorded grant deed or other appropriate conveyance A. For a stock coup or a long-term lease, an assignment of the stock certificate or leasehold interest. B includes oil, mineral, and water rights currently owned by seller unless excluded elsewhere. Title will vest according to buyer's written vesting instructions. The deed must include buyer's post-closing mailing address so the recorder can mail the original to buyer. Then the contract warns, the manner of taking title may have significant legal and tax consequences. Consult an appropriate professional. Section 13G. Type of title insurance policy. Default protection for buyer. Buyer shall receive an ALTA homeowner's policy of title insurance or equivalent, if applicable to the property and buyer. Escrow holder must request this policy from the title company. If ALTA homeowner's policy is not offered, buyer gets a CLTA standard coverage policy unless buyer chooses another policy and instructs escrow in writing and agrees to pay any extra cost. Buyer is advised to 1. Talk to the title company about A. Availability, B. Differences in coverage, and C. Differences in cost between ALTA, CLTA, and other policies/endorsements. 2. Review the preliminary report, which should indicate what type of policy will be issued. If the prelim does not state the type, or buyer is not satisfied with the offered policy, buyer may choose a different policy at their own expense. Finally, if under Section 3Q, 8, buyer will not receive a title policy at all, then this paragraph about title insurance is disregarded.